My name is Joe May, Hawkins County Bar. I represent the appellants down at Surgoinsville and its beer board.
Mr. May, would you care to move that microphone a little closer to you?
Yes, ma'am.
Thank you.
I wish to reserve 5 minutes. This cause concerns a beer ordinance separating the sale of beer from churches, schools, and places of public assembly. The standard to be applied by the courts in the review of legislative acts is what's denominated the any conceivable reason standard. Our Supreme Court has said that illegal, arbitrary, and capricious, fairly debatable, rational basis, any conceivable reason are all the same. That's McAllen against Memphis, cited in our brief. The trial court decided this cause by making the subjective motivation of legislators, the Board of Mayor and Aldermen, an issue to be determined by courtroom fact-finding. We would say, in doing so, the court made a fundamental error. The relevant standard of review requires an objective review of the substance of the ordinance at issue, not a subjective review of the motivation of legislators. It's the position of the appellants, and we argued this to the trial court, that the standard to be applied is found in a 1938 decision of the Supreme Court of Tennessee, which has never been disturbed, Madison against Maryville, cited in our brief. In Madison, the issue to be decided was said to be, it is next contended that the ordinance in question was passed and adopted for the sole purpose of preventing the complainant from conducting the business of selling beer, and that this was the motive behind the passage of the ordinance. The holding of the Supreme Court of Tennessee is this court cannot go outside of the statute presented for an examination and look into the motives for their enactment. The rule holds true as regards municipal ordinances. If the enactment is valid, the motive behind the enactment is not to be inquired into by this court. We cited in our brief the long and well-established history of both the common law and the constitutional basis for that ruling, and set forth the many, many Tennessee and federal decisions which affirm its vitality today. In this cause, Appellee initiated a review of the town's beer ordinance by appearing several times before the legislative body. We point out that the legislative body has no authority to accept or reject an application. It has no authority to grant or deny a beer permit. It is the exclusive jurisdiction of the beer board. When she appeared before the legislative body, a review of that beer ordinance was made, and it was discovered that the long-standing practice of the beer board in measuring the distance of separation between churches and the sale of beer had not been adopted by ordinance. It was a practice of the beer, or policy of the beer board. The Board of Mayor and Aldermen adopted a curative amendment to the beer ordinance that established that policy and practice by ordinance.
Is it true, Mr. May, that this was the first time anyone had applied for on-premises beer sales? So they'd never really had an opportunity to apply the statute to on-premises sales?
In point of fact, that is true. There's never been an application. In fact, none of the part-time citizen legislators had ever read the only 2 words in that entire ordinance where it said on and off premises. The distance and
They have issued beer permits, though, haven't they?
Oh, yes, they have issued beer permits.
And when they issued the beer permits, at the time the application was filed, what did they use as an ordinance?
The ordinance states a 300-foot separation. The practice of the beer board was to require that measurement to be made from property line to property line. In this record, we cite to where the chairman of the beer board states specifically that that's always been their practice. There has been no change in the distance or the method of measurement by policy or practice of the beer board by this ordinance. I guess the thing that the town relied on, well, that I relied on since I wrote the ordinance, in 2002, the Attorney General of Tennessee issued a formal opinion to the city of Arlington in which the question was asked, can you create more than one zone and have different or differing regulations in those zones? We cited that opinion in our brief. And the Attorney General said that so long as you have a properly defined zone by geographic means and everyone in that zone is treated the same, there's no reason not to do that. And he cites a number of cases, including two where towns, the town of Harriman and the town of Johnson City, city of Johnson City, both have done this, where they've treated newly annexed areas differently than the existing city. The reason for changing the method of measurement was testified to in the trial court. The town actually had been bypassed by the new 4-lane highway that replaced the old 2-lane that went through the center of town. Businesses, including recently a big box store, considered being on that bypass. And they realized that the larger parcels on the bypass had an internal buffer that would accommodate measuring just from building to building. In fact, the trial court expressly found, and we cited where in our brief, that the court understood. You have large parcels of property, and it might be a great distance internally on the property just to the property line. Obviously, encouraging that kind of development is something towns do generally. Had the trial court accepted the factual basis that it did of recognizing that internal buffer, we probably wouldn't have been here today. But the trial court went on to look at what was the motivation in adopting the ordinance. Well, obviously, if you discover a defect, you attempt to cure it. And that's what the town did.
Is it your position, though, that the trial court is not allowed to look at motivation at all and under any circumstances? Because I think what the trial court sort of says is this change or this new these new requirements for measurement were passed somewhat surreptitiously based on the timing and appear to be passed specifically to prevent this particular person from getting a permit. Can the trial court consider that at all?
Well, motivation based on the long-standing common law and constitutional basis is not within the jurisdiction of the courts by our Tennessee Constitution and our United States Constitution.
Ever under any circumstances?
Well, ever under any circumstances, racial issues, I mean, there's an exception to virtually every rule. I mean, what's the old saying? It's possible to strike a safety match on a wet cake of soap, but it's not very likely. The significance, though, is there was no change. When you say that it was designed to specifically prevent this person from having a beer permit,
You could finish.
That's not this
not
case.
the entire argument.
that's not this case. There was no change in the distance. There was no change in the method of measurement. The only change was that it was adopted by ordinance as opposed to a policy or practice of the beer board.
Thank you, sir. You have your rebuttal time. Yes, sir.
Thank you, Judge McClarty. Francis X. Santori Jr. from the Greene County Bar for Amanda Wolfe, who is the appellee herein. And Judge McClarty and Judge Davis, let me answer some of the questions that you pose my good friend and fellow colleague, Mr. May. First of all, remember that in this case, originally, there was no dual measuring system of boundary line to boundary line. Therefore, they being Surgoinsville and the Beer Board, a system of measurement that was by default under the statute building to building. Under that, Ms. Wolfe's particular business would have been eligible in any event.
Let me ask you that because
Yes.
I understood Mr. May's argument to be different, and his was that the statute itself doesn't, or the ordinance doesn't say how the 300 feet is to be measured. And he says that by policy and practice, it was property line to property line. So, and you're saying it's door to door, building to building. So what is the record going to tell me when I look at that?
Well, Your Honor, I'll say this. The record is going to be replete with nothingness, most respectfully, Judge Davis, because it doesn't say anything most respectfully about that.
That's going to be super helpful.
All right, there were three people who testified. And by the way, it was the appellant who got the opportunity to bring people in to testify. Remember this, honored judges, in a certiorari hearing where really you should take care of things just from the record below. Mr. Graham testifies, quote, okay, the measuring on a small lot, a neighborhood lot, you've got, of course, and this is Judge Wright quoting what he says, a small area to design your ordinance. On the 4-lane, designing your ordinance would be fairly different because of the way the buildings will be situated and so on. It could make a big difference on how we design the ordinance, so that was done for that reason, close quote. Judge Wright finds the chairman of the Planning Commission says, quote, well, on the 4-lane, we could have larger parcels. We did have a grocery store and whatever, and it would be measured differently. So this is what was said. They articulated no reason. Now, I want to say this. I was not, as I think the brief has told you, representing Ms. Wolfe at the trials in this case. I just started representing Ms. Wolfe at the post-trial motion and here on appeal. So I wasn't present here, but I did read the record. 3 people testified, most respectfully, for the appellants in this case, and none of them could articulate, even though, and again, you all know more law than I do, I don't think that in a certiorari hearing that basically it's somewhat of a favor that Judge Wright gave them to allow people to supplement the record with their testimony. So here they are, they're supplementing the record, they're trying their best to articulate a reason, and they can't. They absolutely cannot. So most respectfully, to answer your question, Judge Davis, there was no policy or procedure. But let me stretch it a little bit further. This basically goes to the full question of what is arbitrary. And if that doesn't show, most respectfully, this honorable court, that what they're doing is arbitrarily passing and applying legislation by saying, oh, well, it's the policy and the custom for us to do that. Well, you, honored judges, may be living in an area which is not zoned for a garbage dump. Then it may be their policy and custom to say, and I'm saying this with a bit of levity, but just to give you somewhat of an example, it may be a municipality's custom and policy in Knoxville or Chattanooga or Morristown to say, okay, well, we're going to, as a matter of policy and custom, but not as ordinance, put a garbage dump right next to homes that are owned by judges on the Tennessee Court of Appeals. Now, that is the same thing that they most respectfully are saying herein. And I think that when they do that, then they have exceeded what a government should do. Now, honored judges, we all know that we have a system of laws and order in this country. It's the greatest country in the world. We all know that we have such laws, and our founding fathers have given us the provisions and the ways to make these laws. And Mr. May and I have cited buku cases. We all know that anything that's rationally based that a government is passing is going to be constitutionally and legally fine, because that's normally for the public weal. We understand that. And we understand, particularly with respect to alcoholic beverages and beer, there is an importance in the government passing legislation, be it city, state, federal, that will regulate that, because we don't want our children, our churches, our schools to be tainted perhaps with drunkenness or something like that. But this is most respectfully I hate to say this, somewhat of an abuse of power. They tried to, Ms. Wolfe comes into the office of the clerk there in Surgoinsville. The clerk says, and Ms. Wolfe is not legally schooled, of course, that's no excuse, everybody's presumed to know the law. But she comes into the office of the clerk and she says, I want a beer permit. And the clerk, the record's gonna say, well, I just don't know if we have any, beer permit here, okay? Or any ordinance or way to pass a beer permit or give you a beer permit. She comes back a second time, or actually mails it in with her attorney. She appears before the county, not the county commission, the board of mayor and aldermen. Mayor Graham, who also sits, by the way, on the beer board, is hemming and hawing around, most respectfully, and saying, well, I don't know about this. I've never done anything like this before. We're going to table this measure, etc. I'm sort of trying to shortcut things because I don't want to get a lot of quotes in. I've quoted this in my brief, and I have only 6 minutes and 45 seconds here. Then, most respectfully, when they find out that she's going to push this, on December 16th, they publish in the Kingsport Times News. Yes, it is a newspaper of record. The better newspaper of record is the Rogersville Review. In fact, my client's address is actually a Rogersville address. That's how far out they finger annexed in Surgoinsville. Her building and establishment is in the town of Surgoinsville on one side, and forgive me if I'm mistaken, and Mr. May can correct me, but on the other side of Old 11E, that hasn't even been annexed, okay? So, they give her notice on December 16th, don't provide her any personal notice, but publish it in the Kingsport Times-News, not the Rogersville paper in Hawkins County, that there's going to be a meeting of the board and mayor and aldermen to pass a first, and I think, and I may stand to be corrected, second and final reading of this brand new ordinance on December the 21st. She shows up, they pass it. It's signed, sealed, get this, on Christmas Day. Then 2 to 3 to 4 days later, I think it may have been a maximum of 4 days later, is when they have the meeting, they being the beer board, to decide on this particular license. Most respectfully, honored judges, if that is not arbitrary and that is not capricious, then the words and the definitions have no meaning. In summary, I want to quote from you what then senior judge, he'll be retiring in a week, Judge Thomas Wright, said about this situation. Quote, "The town officials are unable to articulate, in my humble opinion, any rational basis for adopting the different standard other than their obvious desire to prevent, parenthesis, appellee, close parenthesis, from obtaining an on-premises beer permit. They contrived an amendment to keep her from being able to sell beer, but allow others who would be similarly situated to sell beer. They did it intentionally, and they cannot articulate a rational basis for doing so. 300 feet is 300 feet. If you're trying to protect the morals of the people of the city of Surgoinsville from being impacted by the sale of beer for on-premises consumption within 300 feet of a place of public gathering, then that's fine. But 300 feet is no different on the 4-lane than it is on the 2-lane. That is the crux of this case. And furthermore, and I guess one final thing, Rule of Appellate Procedure 13D, most respectfully, says, of course, that you fine judges are to review findings of fact below de novo. We understand that, but with a presumption of correctness. I will most respectfully bring this to your attention. The town of Surgoinsville had a bite of the apple in the cert hearing before Judge Wright. It had a second bite of the apple when Judge Wright opened up what is the normal ambit of the cert hearing to allow them, not the person who was aggrieved who brought the cert action, but the person or the people against whom the cert action was brought, to introduce testimony regarding whether there were a rational basis for this. So that, most respectfully, is the second bite of the apple. And the third bite of the apple comes when Mr. May files his Rule 59 motion. And the court basically has said, I most would respectfully suggest 3 times, that there was no rational basis for this ordinance. We most respectfully assert that the judgment of the lower court, of the special judge, the circuit court of Hawkins County, should be sustained by this honorable court. We have 1 minute and 37 seconds. Do any of you have any questions for me?
I hear none. Thank you.
Thank you.
Yes, sir.
First, let me address the policy and practice. In Volume 6, Exhibit 1 of the record, the transcript of the hearing at page 11, lines 18 through 21, Beer Board Chairman case. It's always been considered by the town to measure from property line to property line. That's in this record. The factual basis or explanation or reason or conceivable basis for adopting a second zone is set out by the trial judge, Judge Wright, in the transcript, again, page 52, lines 9 through 16. I understand the idea that the generally larger parcels along the four lane are going to provide a naturally occurring buffer. And he goes on to understand exactly what the witnesses that testified at the trial explained the factual basis for that. Now, the counsel for Appellee has talked about this public notice. I would point out that at page 6 of their brief, they concede that the notice for the meetings at which the ordinance at issue was adopted were, and I quote, barely in compliance. In page 15, they again concede that that notice for the meetings at which the ordinance at issue was adopted used the minimum number of days allowed. This court earlier this year decided a case styled Madrone against Morristown. It's at 2023 Lexus 5, 2023 Westlaw 164-173. It discusses in detail what's adequate notice. Adequate notice does not require perfect or exhaustive notice, even for special meetings. Adequate notice is just that. And it's under the totality of the circumstances.
Let me ask you something here.
I'm sorry?
Are we really looking at your ordinance? Or are we looking at whether or not you can actually create an ordinance making certain requirements after an application has already been filed and pending, where you have issued your beer permits prior to that time to others, and now you have an application for one, and before you rule on that application, you create an ordinance or provision for that?
Actually, that was discussed at the beer board by then attorney Phillips. And as I pointed out to him, that was decided almost 50 years ago. There's a case called Kaufman against Washington County, cited in our brief. In Kaufman against Washington County took almost 15 months to adopt beer regulations after the application was made. What the Supreme Court of Tennessee held is it is the beer ordinance in effect at the time of the hearing that is applied.
In that case, though, if I'm remembering the case correctly, that was a situation where the county had been dry. It had just changed over to allowing alcohol, so there were no ordinances in place dealing with the permitting for sales of alcohol. So it was sort of like, well, if we're going to permit, we need to have some sort of criteria or procedure. So there was just nothing in existence at all. And the court said, well, it was okay to wait until they adopted standards.
But that was not the rationale they used in making their ultimate decision. I'd also point out that the Board of Mayor and Aldermen considered adopting regulations dealing with on-premises sales. It was an election. The board, as it was then constituted, did not adopt that, and a new board came in and adopted the curative legislation that I spoke of. The question of sunshine was not raised in the hearing before the beer board. It was not raised in the petition for certiorari. It was not argued to the trial court. There was no request of the trial court to rule on sunshine compliance. There was no post-trial motion made for a new trial, additional findings of fact, or amendment of judgment. The appellee abandoned and waived that issue by failing to properly preserve it or even bring it to the attention of Judge Wright sufficiently for him to recognize that they wanted a decision on that.
Thank you very much. I want to thank both the attorneys for your presentation. Your case has now been submitted to this court for resolution.